So, hey, my name is Amar, and this is Alex. And today we're going to be talking about how you should title your house. And one thing that's common is people ask us all the time about using the TOD, transfer on death designation on a house. And we're going to talk about some pros and cons about that, as well as other ways you should be titling your house. But first, we got to do some disclosures. Alex, do you want to tell us your disclosures, and then I can...
So this is purely marketing material and legal education. And so this isn't meant to enter into a client attorney relationship with anybody unless you contact and we have a retainer agreement.
Yeah. And then the same thing for us. I mean, look, we're here just to give education. We haven't taken your accounts or your situation into account. And nothing's considered advice. It's just all education. So, Alex, I mean, how do you title your house? I mean, I get this question all the time from prospective clients as well as clients. And I think there's a lot more to it than just joint tenants or whatever. But why don't you start with that?
So that is one of the most common questions that I get as well, Amar. And I will say that my answer tends to be the best way you can title your property is going to usually be with a living trust, but we're not going to talk about that today. And instead, we're going to focus more on transfer on death deeds, because that's one of the most common questions I get from clients when they call me. Can I just do a transfer on death deed to transfer my home to my kids? And let's start with saying, like, there are many different ways to create a transfer. So obviously, as I mentioned, my preferred method is with like a living trust, but you can also do it with a will, with joint tenancy, and one of the other options is a transfer on death deed. So there's many options. Today, we're just going to focus on the transfer on death deed. And so,
go ahead. What is transfer on death? Like if you were to make it very simple, what would you say transfer on death is?
It's very much like a life insurance policy where you name your beneficiary, and upon your death, it's a contract that's created and it transfers your life insurance policy proceeds to your beneficiary. So that's basically what the same concept is for a transfer on death deed, except now instead of life insurance policy, we're looking at the actual title to your home. So upon your death, you're creating a contract so that it would transfer to the beneficiary that you've named.
Cool. So it's one of those things, I guess it has to be recorded somewhere too, right? Like you have to go to the county or exactly. I don't even know if you can go to the county now with COVID. You have to do it online or something.
There are some virtual recording places, or you mail in your stuff to the county recorder. But essentially, to do the transfer on death deed, it's not just like you put it on a piece of paper and record it. It's actually a very specific form that California has come up with. And the rule is that you have to use a form that's substantially like the form that they provide. And so really the best thing to do is just use the form that they give you if you don't want to like mess up, right? So use that form. And so let me start with this though. I'm not a fan of transfer on death deeds. So I'll be very upfront with that. And I would say that a lot of my colleagues also aren't very big fans with that. And I'll explain that in a little bit more detail. But I think to start with, it is a good idea just to kind of give the parameters of what it is and how do you do it. So it is a rule or a law that was passed by California, went into effect in 2016. It actually was supposed to expire earlier this year on January 1st of this year, but it's been extended to next January 1st. So we still have some time, and I think the legislatures are still trying to figure out if they're going to extend it even more. That's, remains to be seen. But if you did it prior to that time, it's going to be valid, even if it then subsequently expires. So it is a law that was passed, and the idea here was that they wanted to provide a way for lower income families to be able to pass their home to their loved ones and avoid probate, right? Because probate is the big thing that everyone fears because it's so expensive.
Avoid it. It's like the plague.
Right. So the statutory form was created, and And as I mentioned, it has to be pretty much that form. There's no reason to reinvent the wheel. Just use the form that's provided, and it has to be signed and notarized. And here's the kicker. It has to be recorded within 60 days of the signing. And so sometimes with deeds, you can get away with not recording it right away and there's no issue. It's still valid. But with the transfer on death deed, it has to be recorded within 60 days or it's not good anymore. It doesn't work.
Yeah, and so if you're listening to this and you're not in California, you should probably just go to your county recorder's office to figure out what the rules are in your state or your county, right?
Right. And well, here's the thing. The county recorder most likely is going to say, we can't give you legal advice, so please go seek the advice.
It's an infinite loop.
Precisely. So, I mean, really, at the end of the day, it is always better to get legal advice before you make a decision, especially something as big as this. And as I mentioned, I'm not a big fan of it, but I do think it's important to at least explain what it is and then gives the pros and cons. And then, each person can make their own decision. And I strongly advise you to go seek the advice of an attorney, right? Because your particular situation might be very different and this may or may not be a good tool for you. So with that said, let's start with what the pros are. As you can imagine, Amar, make a guess. What do you think is one of the biggest pros for
I'm going to throw a dart out there and say it avoids probate.
Yes, that is exactly it. So it avoids probate. So that is the biggest benefit going for this thing. And it's a less expensive way of avoiding probate instead of doing a trust, right? A trust,
well, yeah, that's true.
It does take money to create the trust. So theoretically, this tool is meant to be a more accessible, affordable option for individuals, or at least that's what the legislatures had in mind. So for me, those are really the only two pros that we have going. And so let's jump into like what the cons are.
Yeah.
So the downsides of creating a transfer on death deed. So here's the thing. You can only do it with specific types of property. So if you have commercial property, this is not for you. You cannot use it. Really, it's meant for like a single family home, your condo, things like that, right? So it's meant only for specific types of real property. And in my opinion, it's not a good option if you have multiple beneficiaries. So if you have multiple beneficiaries, I don't think that this is a good option at all for a variety of reasons. If your beneficiaries may not want to own that property together, but if all of a sudden they're now co-owners, there may be conflicts there versus if you had it in a trust and you're allowing the trustee to sell it or liquidate it or do whatever it is they need to do to divide those assets. It's a lot easier with a living trust. But so in my opinion, I don't think it's a good option if there's multiple beneficiaries. It's also not a good option if the beneficiary that you're wanting to benefit is a minor. Not a good option at all, because minors can't own they can't own property, right? They can't manage it for themselves. Yeah. So if you name a child as the beneficiary under this TOD, well, guess what? They're still going to end up having to go to court to get a guardianship, right? So it's like, well, you didn't really solve anything.
You didn't solve anything.
Right. So we covered the minor children, probably not a good idea for multiple beneficiaries. And so here's the big kicker. It's also not a good option if the beneficiary intends to sell or refinance the property that they're receiving, because title companies will not issue a title insurance if it's less than 3 years from the date of death. And so that's a really big thing, right? So if you receive a property and you're intending to sell it or you need to refinance it to take some money out, well, guess what? You're out of luck. Most likely you're not going to be able to find a lender who's willing to do that.
Yeah, it kind of like puts like the handcuffs on your beneficiaries from doing anything.
Precisely. Yeah. And if that's one of the benefits of owning a piece of real property, is that it's for you to decide like how you want to best manage that. But it really does put a big limit. In 3 years, that's a long time. So that's a big one. And that tends to be one of the biggest reasons why attorneys are not big fans of this, because we have that 3-year mark, right? And then during those 3 years, the reason that the title insurance company
I was just going to ask,
right? Like, why is the reason? Well, the reason is because during those 3 years, your creditors, the creditors of the decedent, the person who gave you the property, those creditors can come after you and say, you know, you received this property from the decedent, he or she owed debts, we're going to get paid from that. And that is the number one reason why title insurance companies will not touch a home that was transferred via a transfer on death. Versus if you went through probate or a trust, there are mechanisms in place to really cut that off after a year, right? And so that's not the case with this transfer on death deed. So for me, it's like, okay, you're saving a little bit of money, but at the end, like, you're kind of creating more problems for yourself.
A ton of headaches.
Yeah, absolutely.
Yeah. This actually reminds me, I had, like in a previous career, I was working with a family, and, you know, husband had deceased, mom was living in the house, and they had 3 children, and one of their child became like the caregiver for mom, right? And, you know, after a year or two, the other children noticed, like, you know, fishy stuff going on with the finances. And one of the things that they noticed is the mom took the house out of the trust and did a transfer on death to that child, right? And so this could probably open up like elder abuse, or like a lot of things that, you know, when you're older in your years, that you don't have the guardrails or the safety nets that you do with like a proper trust document, where you somebody has to say that you're of sound mind to make those type of decisions, right?
You are exactly right, Amar. And that is the other big reason why attorneys are not fans of this. And especially the elder law attorneys in California, they were up in arms, because you are exactly right. That scenario that you gave is exactly what elder law attorneys and just estate planning attorneys fear, is that now our most vulnerable population, which is generally like our aging population, right? Our elders, they're subject to predators, who someone could come and just say, oh, sign this. And it doesn't have to go through an attorney. There are no protections in there. Others may not be aware of it, you know, but it gets recorded. And so, yes, that, in my opinion, that is going to open up a lot of potential litigation. It's so much better when you go through an attorney, and that attorney is advising you. You've been fully represented. You understand all the sides to it, and you're going forward with a decision. That's going to hold up a lot better than just, you know, randomly some person comes and says, oh, sign here, or a caretaker, or there's disharmony amongst the family members, and one of the children says, oh, here, mom and dad, or mom, sign this. Yeah, absolutely. I think that's a lot of trouble right there.
Yeah. Well, there you have it, folks. There are multiple ways to transfer a house to your loved ones, but go talk to Alex and get a professional's opinion of what makes the most sense for your situation. And 9 out of 10 times, you're probably going to lean towards having a trust. And that trust is to protect you as well as to protect your future beneficiaries. So I think that will wrap it up there. And if you guys have any questions or comments, please leave it below, and we'll do our best to answer them. Thank you.
Sounds good. Bye.
Bye.